Good morning, one and all. I am Dr. Sandeep Raut, Innovation Manager at Innovation and Incubation Centre for Entrepreneurship, also called as IISER Bhopal. I welcome you all for today's workshop on Introduction to Patent Search and Patent Filing in India, organized by IISER Bhopal in collaboration with Centre for Science and Society, IISER Bhopal. Dear friends, ICE is a DST supported technology business incubator at IISER Bhopal, which organizes several events such as conferences, workshops, seminars, and competitions to inculcate innovative entrepreneurship among the students and faculty members. And recently, ICE has started the virtual entrepreneurship talk series, of which today is the fourth session. Uh, when we talk about innovative entrepreneurship, intellectual property right lies at the heart of the innovative entrepreneurship. And thus, the basic knowledge of IPR is very crucial as like the domain knowledge if you want to translate your in-house generated ideas into a commercial venture. Recently, Institute has also established Center for Science and Society to enhance Institute's outreach in case of industry and societal outreach. And the major objective of the Center for Science and Society is also the IPR awareness. Dr. Amjad Hussain, who is CEO and coordinator of ICE, is also a coordinator for Center for Science and Society, and he will brief us about the initiatives of CS2. So as the IPR awareness is a common objective of ICE and CS2, we have collaborated to organize today's webinar, and it's a great honor and privilege to have Dr. Rahul Kapoor as a resource person for today's event. Dear friends, before we start the event, I request all the Zoom participants to please keep yourself muted throughout the event for the smooth conduct. In case you have questions, you can text us in the chat box. We'll try to take the questions in between or at the end of the workshop. And in case of certificates, all the registered participants and those who are attending this session will get the said certificate in 7 days of time. So without any further ado, let me invite Dr. Amjad Hussain, CEO of ICE, to talk about the CS2 initiatives and also to formally welcome our today's resource person. Over to you, sir.
Thanks, Sandeep, and good morning, everyone. I welcome you all for the first online IPR workshop, which is a joint initiative between Center for Science and Society, IISER Bhopal, as well as Innovation and Incubation Center for Entrepreneurship, IICE, at IISER Bhopal. As you know, that ICE is a technology business incubator supported by Department of Science and Technology, Government of India, and IISER Bhopal. So it's a joint initiative, and we already work towards building a network of startups. So our goal is not only to conduct the event and network and sort of webinars and seminars, but our main focus is to create a culture and ecosystem for the startup promotion. ICE do provide support in terms of infrastructure, space, mentorship, networking, and also guide startups in order to raise funds and also to become successful and how to progress further. With ICE, there is always a challenge that when a faculty would like to start a company, they also would like to transfer or also want to transfer the technology from their lab to the startup. Or even if they're not doing startup, if they would like to transfer a technology which is developed in their research lab to another company which is already existing outside, there is always a challenge. And then they always have a question that what is the right time to talk to the industry, whether they should file an IPR first, whether they should disclose the invention, how much to disclose, when to disclose. So these are some of the very important questions, especially if you are aiming or hoping that your technology which you have developed in research lab can be translated or have a potential of translation to the outside world. So in order to streamline the entire IPR process, Institute very generously has taken the initiative and established the Center for Science and Society. which has different verticals like outreach, building of endowment, and one of the vertical is also the IPR streamlining. Recently, we have put forward the process of invention disclosure format, which is basically a form where a faculty can approach us with those details, and then an expert panel can sort of evaluate the invention disclosure in a confidential manner and see whether that is worth filing for the IPR. Institute also has a generous support system for the filing of IPR and also supporting the faculty members and researchers in terms of providing the fee either through reimbursement or through other processes, and that we are still sort of streamlining. Recently, we have received a couple of proposals, and one of the IPR evaluation has been recently done, and a couple of more are in pipeline. We intend to have, I would say, more specific workshop, and then sort of streamlining the IPR, focusing on domain knowledge. But today's workshop is more about a generalistic approach and to educate all of us about the IPR, the basics of IPR, patent search, and all. And with that, I would like to invite today's speaker, Dr. Rahul Kapoor. And let me also take the opportunity to introduce Dr. Rahul Kapoor for today's workshop. Dr. Rahul is the founder and director of Turnip Innovations with more than 10 years of experience in filing and searching and patenting the intellectual property. He is a PhD from LUT University. I searched for the full name and it has a complicated name, so I will call it LUT University in Finland, which is one of the finest place in Finland. And his PhD was in innovation management. He also published more than 15 papers in very good international journals on innovation management and IPR. And he was also a data architect of IPGRAM, which is a global data analytics platform, deals with millions of patents and creating the database. So with that, I would like to invite Rahul Kapoor for today's workshop. And I hope all of you, including myself, will find it meaningful and helpful, and it will add to our knowledge in terms of understanding the IPR a little better, and also help us translating more technologies for the public good and societal benefits. So thank you very much, and I invite you, Rahul, now for conducting the workshop. Thank you.
Thank you so much. Thank you so much. Really, it's a pleasure. I really appreciate that you've invited me, and I am myself looking forward to this session. So thank you very much for the introduction. So yes, my PhD was related to patents, and it was related to basically how to use patent data. So as such, I am a data scientist, but I have been working in the field of patents for more than 10 years. And we have done a lot of patent search projects, a lot of patent technology commercialization projects. With my experience, I want to share with you some of the best practices of search and some of the best practices also to mature your innovations. We will talk about search and filing today. So let me share my screen. Just a moment, please bear with me. Yes. Yes, okay. I'll share with you some of the things regarding patent search and filing. And in the filing, I'll try to describe some practical aspects on the mindset that innovators should have and the filing process in general. So as such, patent search is a very vast concept. And I think that learning patent search is rather easy. The only thing that differentiates between highly professional patent search and some amateur who's doing patent search is usually some experience. So while in principle the concepts are rather easy, But the thing is, you need experience, and over time, you need to also understand about patents, where to find information, and how to really do a comprehensive search. So I will try to keep the session rather general in terms of search, and probably I'll give you some resources so that you can take it forward, take your learning forward, and really implement it in your use cases. Okay, so without further ado, let's just begin. And please feel free to write on the chat if you have any questions, or for that matter, if you have the access to your mics, you can also interrupt, because as such, I cannot see you, so I cannot find if someone wants to speak. So please feel free to write on the chat. Every now and then, I'll also ask you to write certain things on the chat so that we keep this interactive. And yeah, let's begin. Yeah, okay, I can press the, okay, single. Okay, so agenda for today, key patent concepts. We are going to learn the concepts while we do some exercises. Okay, so I don't intend to show you any theory or give you a lot of slides. So we will learn some patent concepts using the search tools, and also we will learn search. So we will, and then we will look at patent filing in India and in the second half of the session. So let's say we have about 1 hour for patent search, and the rest we will keep for filing, and also some ideas, some notes on how to mature your patents, how to mature your ideas into patents. So, okay, why patent search is important? I mean, actually, it's very simple why it's very important. But the thing is that in my experience, I have seen that most people don't get it. The thing is, the most important reason is to avoid reinventing the wheel. And it is quite incredible that it sounds obvious, but a lot of researchers, they think that they're doing something new, but in reality, they are not. When they get professional search people involved, or when they themselves do search, they get kind of a reality check after they have done already work for many years, that okay, someone has already done it. And actually, there is even like some research done which show that even global 30% of the R&D is basically R&D costs are wasted, because simply people do what they feel like doing without finding out whether such a thing exists. So this is very normal actually. Even like I've done research, so I usually it is a kind of a personality of inventors. They think that they're doing something new, but it's good to keep grounded and be on the lookout for what's available in the market, so that you don't do redundant work. And of course, for big companies who are launching products, it is important that they do a patent search to avoid inadvertently infringing on others' patents. So it's also important when you launch products in a certain market, you want to find out that you're not inadvertently infringing certain, if your product is protected by a patent, for example. Big companies are also keeping an eye on competitors and technological trends. Even as a young researcher who is really enthusiastic in innovation as a topic, it's good to search patent databases to see what's out there, what's new, learn from what's happening. So it also helps you be more innovative, if you do regular patent searches. Like I said, you can learn from the latest scientific knowledge, how things are done. Because if you really want to be successful in being a patent holder, being an inventor who has one or multiple patents to their name, you really have to know what others are doing, because it's like playing a sport and not practicing. It's like that. You cannot just play a sport, but you need to know how it's done, what are the rules of the game, and these are known only by patent searching. To see, for example, I'll show you some patents today, like how Apple writes their patents, how they use pictures in their patents. These are some things which are like, they are so good. They have such, of course, they have a lot of budget and big teams for drawings and writing the text of the patents. But just by seeing those patents, you can get inspiration and your own ideas how you can go about writing your patents. And enriching your own innovations and distinguish your own innovation from prior art. So search is also very important. First of all, you get ideas. So say you pick 2 ideas from 2 different patents, and you bring in your own idea together, and together it becomes something in innovative. So it's very usual that innovation is done like this. that you bring together multiple ideas and together it creates something that substantially improves the technology or substantially helps the society solve a problem. And of course, you need patent search to distinguish from prior art. So the thing is, a lot of clients have come to us and they have said that there's no prior art in their field. It's usual, we hear that. And the thing is, we don't even work with those people simply because there is always prior art. And if there is no prior art, then something is wrong. So either that you should not be in that field, you should not be doing any research. So there are many issues if there are no prior art at all. So because the prior art is needed so that you can distinguish your innovation. You can say that, okay, this is the prior art, this is how the world looks right now. We have added certain things, and that makes the invention a much more important thing. So yeah, these are some of the aspects of patent search which are very overlooked, like how important it is in your journey for having, say, one or even hundreds of patents to your name down the years. And the amount of patent data is exploding. I'll show you a graphic. There's actually 3.5 million patents filed per year in the world. So with that much data, so you need good searching skills simply because you need to make sure you find the right patents, the ones that are irrespective of the language. Even you want to find which patents are important to your field. So yeah, this is the graphic which I was referring to. Do I refer to the chat every now and then? How? Because I think I see. Okay, you may share. Okay, I see some direct messages. Okay.
So hi Arun, Rahul, there is one question. Could you
Yes.
explain the term prior art?
Yes.
So if there is a specific question in chat box, I would like to ask that question.
Yes. Okay, I'm also seeing. So yes. So yes, prior art is nothing but all the knowledge that exists up until the point where you created the invention. So that is prior art. So basically any public knowledge that exists that precedes your invention. Suppose you invented something new, and prior art would be all the knowledge related to your invention that already exists and which might actually invalidate your patents, because it could be so. So we will discuss it a bit more during the lecture, because prior art is a key thing. Because when you're doing patent search, essentially you are finding prior art that, okay, to make sure that you are totally new. What you are doing is novel, and what you're doing is inventive. So that's sum total of all knowledge preceding the invention. That's prior art. That's how I would define it. So we will come across this term many times in this lecture. So you will get to know the nuances and all the things that it can mean. So even suppose you create an invention and there's a YouTube video that basically shows the same thing that what you have done. So that YouTube video will act as prior art to your invention. That means that YouTube video can invalidate your patent. Your patent might get refused at the patent office because they might cite the YouTube video and like that. So usually the prior art is past patents or past research papers, journal articles, but it can, in principle, in theory, be anything public. Any public knowledge. Your examiner at the patent office is going to look at all public knowledge out there which can invalidate your patent or which can say that, okay, this has already been done. So yeah, okay, I hope that is clear. For now, that's also enough. So this is the filing trend. If you see this picture, it's quite incredible, this picture. So around 2012, China became the largest patent office in the world. So they beat US, who's now around 600,000 patents they are filing every year. And China is filing more than 1.5 million every year. So, but of course, there are also some questions regarding Chinese patenting, that they are not very highly valuable and so on. But if you see, in principle, all the countries have growing trend. That means there's a lot of demand for patents. If you see in the last 40 years, since 1980, there's a lot of demand for patents. And it is also very closely related to economic growth. You can see Japan in this picture. Around the year 2000 onwards, they kind of went into a recession. and that is also reflected in their patenting activity, which has declined, because Japan was, previously one of the most powerhouses of technology up until the year 2000, 2005. But you can see the amount of filings went, even lower. But they still are one of the most powerhouses of, technology in the world. So yeah, this is the, global scenario of patents as of today. And you can see around 3.5 million patents are filed every year. So that is why search is all the more important. And trying to do something absolutely new is even a bit difficult if you do really precise prior art search. So yeah, let's move on to some Indian data. Actually, Indian data is not very easy to find, but the thing is, there is annual report, and actually even in IPgram, our own analytics platform, we have some data. So I have compiled some data from annual reports, and I can say for sure, in the latest annual report, they said 56,000 patents were filed in a year. So I was thinking around 50,000 is the number. But they are saying some 11% growth from last year. So yeah, this is the number for India. 50,000 patents are being filed every year. And if you compare it with China, which is 1.5 million, it is 30 times less. And what is even more incredible graphic is who are the top filers in India. So these 50,000 patents, who are the filers? So these are the top filing companies who are filing patents in India. So we have this data from 2007 in IPgram. For India, we have since 2007. So you can see all these companies are foreign companies. And this is where, this 50,000 figure looks even worse, because around 70% of the filings that are being done in India are from foreign companies. So if you look at all Indian players who are like, the big corporates, universities, individual inventors, everyone, they are filing only 15,000. That is 30% of the 50,000 figure. So by any respect, these figures are quite woeful. They are very, discouraging. So in order to boost these kind of figures, of course, IPR awareness is needed. We need basically an entire generation of, scholars, engineers, masters, postgrads to basically take their research forward and file IPR and do businesses with, the technology that they create. So yeah, it's a very macroeconomic problem, but yeah, it is increasing. So about 11% rise from last year, and even in the next few years, with the kind of push the government is doing, it might increase substantially. So okay, just quick overview of what information is out there. So you can see this is a typical patent application. This is a European patent application, but in general, you will see this kind of information in the front page of the patent. So of course, you'll see the filing date. That is a very important date, because usually from that date up to 20 years, you have the protection. And you see the countries where the protection is sought. So also sometimes you'll see where the protection is being sought. So for the same patent, you can file in multiple countries if you have markets in multiple countries. You can see who's owning the patent. So in this case, Toyota is the patent holder. You can see about the title abstract. Usually you see on the front page this is a patent on autonomous driving. Technical classification, we will briefly cover it. We will see how much detail we can go to today. But this is basically like a zip code of technologies, where you classify each technology using a certain
Sir, you are muted. Your mic is on mute.
Yes. Okay, now it should be okay. So yes, technical classification, we will come to it later if, as is needed. So, and you can see the name of the inventors, their location and so on. So there are some information like this. You can Claims, drawings, description, they are not seen here, but if you go further, evaluate a patent document in depth, you will see claims, drawings, and description. So we will look into all these sections a bit in more detail. I think that now, just to get a little bit warmed up, so that we do some exercises, okay, so that everyone can just open a new browser tab and do some really simple exercises to get warmed up and really, understand the concepts that we are talking about. So the first concept I wanted to introduce you is that of patent families. Basically, it's a collection of documents that protect the same technical content, same or similar technical content. So it is possible that you have one invention, you file a patent in India, you think that it is a blockbuster technology, and you think that it can be a global phenomenon. Then you will need to file patents in every country where you wish to sell the products in order to get protection there, because patent rights are jurisdiction based. You cannot file a patent in India and get protection in US or Germany, or for that matter anywhere. So you need an Indian patent, a US patent, and a German patent to make sure you exclude your competitors, to make sure that no one else can copy your invention. So that is where the patent families phenomenon comes. And yeah, these documents can be spread across countries, and it gives a insight. Actually, it's a very good insight into how global the patent is, how global the app, because it's very expensive to get patents in many countries. And that is why I'll see the chat in a bit. I've seen some chat messages, so just let me finish this. So basically, it shows how global a technology is, and it's also a good sign of finding valuable patents. If a patent family size is big, it's some blockbuster patent that the applicant is willing to spend a lot of money to get protection. Okay, we will do one small exercise. I'll see the chat meanwhile. So I just would like you to open patents.google.com. So today we will use two platforms, free platforms for doing exercises. And one is patents.google.com, which is very comprehensive, very good for text search, very good for translated text search. And I've personally done prior art search projects using just Google search. And then we will also search espacenet.com, which is also a great platform. It has comprehensive coverage and so many features that it will be great. So okay, for first exercise, I would like you to see this patent. So I've written the patent number. All you have to do is go to patents.google.com, type in this patent number. It's not recently granted. Actually, it's around 2017. I think it was granted, so just search for it, and we will get back to each other. So meanwhile, I'll just check some chat. Country file a patent? I think not. I think well, yeah. Can the government be applicant? Well, maybe it's theoretically possible that the government in some capacity files a patent. So yeah, you have to look it up. I mean, really, these are very small nuances. Could you explain prior art? I think we've done that. How is it possible to file patents in all countries? There is a PCT route. So I don't know if we'll cover it today, but you can file a PCT patent. Even in the Indian Patent Office, you can file just normal patent application in India, or you can file a PCT patent. PCT patent allows you to extend your invention to about 153 countries, which are which have signed a certain treaty which is called the Patent Cooperation Treaty. So all the countries who have signed that treaty, you can extend your patent, but of course it costs money. So yeah, PCT, Patent Cooperation Treaty. Yeah, you can look it up, or we have covered all these things in separate ways, in different ways. So okay, can anyone write on the chat what they have found? What is the title? What is the invention of this patent that I just mentioned? So the patent number is US 9971415. Yeah, yes, radar-based gesture recognition. Excellent. Expensive figure 2. Well, it's difficult to say, but it can even go up to $300,000 to have a global patent family, including all the attorney costs, filing costs, translation costs, administrative costs, of patent office fees, $50,000 to even $300,000 to file a truly global patent. Excellent. I am so glad so many people are doing this exercise. And what I want you to see in this particular patent is the patent family. And you will see on the right side, actually, I will not do this exercise also myself, because usually I'm also doing it myself, but so many of you have done it. So I think you can, what I want you to see, what this patent is about, you've already mentioned in the chat. Click on the patent family. I think you cannot click on it, but you can see on the right side, there are all these documents with EP, WO, Korea, US, and all these things. So these are all the family documents. And you can hover on the family documents to see the legal status, whether a patent is active, whether it has expired, whether it has been granted, and whatever information that Google has, they will show you regarding these family members. So this is a patent family. They need this kind, because they are manufacturing the phones in Korea. So they of course need a patent of such a technology. So it's radar based recognition. So if you are wondering what this technology is, basically the touch devices are getting smaller, like an iWatch. It's very small device, right? And using your fingers for touch is not very convenient if the device keeps getting smaller. So what you can do with radar based gesture recognition is you can basically make the gestures in the air. So just on the top of the watch, you can make gestures like increasing the volume, scrolling up and down, zooming in, zooming out. These kind of gestures, you can click on patent families. I think so. I think you can click on the patent family members. And how many countries is it patented in? I think it's around 4 or 5 main countries they have patented it, including WO. WO is a PCT patent, which is a WIPO patent. So this is the overall idea of families. It's there's a lot to it. There's a lot about families. There are different kinds of families. Sometimes there can be multiple patents in the same country, which is part of the same family. Like in US, they can have 5 or 6 patents. I think even in this example, you will see multiple US patents in the same family. The time period, there is a timeline. I will mention the timeline in a bit. But yeah, it's a long process, patenting, and then usually it's filed. From filing year, you have 20 years. Yes, open it in eSpaceNet. Dev Priya Kumar, open it in eSpaceNet, type the same exact number, you will get a good idea about the patent family actually. The patent family, it tells you where they have sought protection globally, in which countries they have filed patents and they want protection. EP is Europe, and it's striked out, probably it was lapsed. So either with European patent, what happens is that you have to tell after it is granted, you have to tell in which countries you are actually going to go to within Europe, because usually applicants are not going to all the countries. They go to 4 or 5 big countries like Germany, France, Italy, Spain, and so on. And so Europe might be striked out, and then those patents might be active in all the separate countries like Germany. Actually, our Google patents is not very good in Europe patents. So even in IPgram, we can tell which European patent is active in which countries, which European countries, and where all it has lapsed. Patent need to be refiled. Tushar, I do not understand properly your question. So yeah, please rephrase it and we will see. So okay, I think let's move on, because we will have time to also have a chat at the end of the lecture. So, but yeah, my idea is to just get you warmed up and let's move on. and feel free to search all the features of Google Patents in your own time. Right now, let's move on. So it's just a great tool to search for global patent information. So one more exercise. How many of you know about patent claims? Can you write yes in the chat box if you know? And so I'll just explain a little bit about patent claims, and also we will do a short exercise again on searching for patent claims, for example. So basically, patent claims are like the boundaries of a patent. So we know that patents are intangible assets, so they are in the mind, right? It's knowledge, so it has vague boundaries. But claims is basically a piece of text which helps to define the scope of protection. So just like in real estate, you have dimensions, you have certain amount of square feet which your house covers, and that is your protection, like you own the real estate. So similarly, patents have this kind of protection, like square feet kind of a real estate kind of boundaries using patent claims. And if you think of patent claims as some being defined by X and Y, like the boundaries of the patent, and if there's a product in the market by owning by, say, a third party whose technical features are overlapping with the text of the claims of your patent, that's how an infringement occurs. So basically, this is just to let you know how infringement is occurring. So we all hear about patent infringement, right? But we really don't know what really infringement is. So this is the overall idea, that your claim text is going to be the most important part. That is why actually this is from one of the interviews I was conducting. The truth lies in patent claims, that the amount of protection you get is commensurate to the amount of scope in the patent claim. So this is where an infringement occurs. The text, the technical specification of the product overlaps with the text of the patent claims. So yeah, some people said yes, some people said no, but I hope that this part on infringement is clear. And let's move on. Claims are very important because examiners are going to assess your patent claims, and they are going to either refuse it or grant it. So while the patent is being evaluated in the patent office, claims will be the most important part, and they will look at the prior art. They will look at all the public knowledge that precedes your innovation and see if they can invalidate some of your claims. And even when you say there's a lawsuit, because it's also a thing, right? In patents are property rights, so there is a normal thing that disputes happen. So even when there's a lawsuit, the claims are going to be assessed by the court to assess whether a product has infringed a patent or not. I will not go into these two types of claims, but independent claims are like the broadest scope, standalone claims. Dependent claims are all the claims that refer to another claim, either independent or dependent. So I think this concept can be clear if you just do this one exercise. So we will look at this Facebook's highly cited patent. Please note the number here, search it in patents.google.com. And just write on the chat how many claims you see. Actually on the right side bottom, you will see the claims on the right side bottom, the claims of the patent. And this is basically the text which tells you exactly what is protected by the patent. Just let me know in the chat how many patents, how many claims are there, and how many independent claims and how many dependent claims are there. So if I have to share my screen, I think I have to share my desktop to go to the tagging digital media. Yes, Kalyan, you're right. How much time does it take for examination process after a patent is filed? It varies a lot. In India, even 6 months or 1 year, you can get a grant. But I would say an average is about 4 to 5 years. So Snehalata. Yes, Mark Zuckerberg is one of the inventors of this patent. It's very like the tagging feature. If you remember back in the day, they came up with this tagging feature where in the image you can, click on a certain area and you can tag a person who's in that image and so on. So this is the tagging digital media patent. And how many claims are there? Can anyone write? How many claims are there? Because if you, 2 independent claims, you're right. It's like claim number 1 and 12, I think they are independent claims, and the rest are all pointing to another. In total, there are 22 claims. You're right. So yeah, I will not also do this exercise because I think most of you got the hang of it. But there are 22 claims, and there are 2 independent and 20 independent claims. And all these 20 claims, you will see they are referring to another claim. They are building upon, or they are giving more information about the technology. They are limiting the scope also, that okay. So say you have you've built a automobile, or you can just tell all the features where it can be applied and so on. Why utility model is not promoted? Uh, okay, Samiksha. Okay, we will answer this later. This is I mean I'm not an expert on this because this is a policy related thing. Why it is not promoted? So 1 and 12 are independent. Great, excellent. I am very glad that everyone is involved. And so moving on. Uh, Patent citations, I think in the same patent you can see the citations, or you can see the next patent that I show you. It will be an Apple patent, which is like the highly cited patent, one of the most blockbuster patents you can say of the 21st century. It's the touchscreen patent of Apple. We will come to it. So patent citations are references, basically, like we said, like prior art. Prior art, you can use it as a synonym. References, prior art, prior knowledge, however you want, you can put it. So if you have written a research paper, you always add a bibliography at the end, right? All the references at the end. In essentially, these are what citations are. So even when you have a new invention, the examiner is going to check for all existing prior art, and they will come up with a set of citations. In some countries, you have an obligation to provide all the citations. So yeah, this is citations, and they help you legitimize your patent claims. Basically, with all the patent citations cited in your patent, you will be able to say that, okay, we have learned from all these patents, but we have added so and so subject matter. So just quick graphical idea about citations. Suppose you are patent A, that is, say our frame of reference is patent A. All the patents that it is making citations to are called backward citations. So it can be anything, any public knowledge, just like I said, it can be other patents, it can be research articles, journals, magazines, internet links, YouTube videos, anything out there in the public can be cited in a patent. And then if you see all the citations that patent A is receiving from future patents will be forward citations. So this is like a quick graphical idea about what citations mean. Let's skip this section. We don't want but let's do this exercise. So here is the Apple's very highly cited patent. Just search it on Google patents or google.com. The number is out there in your screen. And let me know how many references are there, backward citations and forward citations. So there is on the right side, on the top right side, there's a lot of information about the patents, where it has cited by, how many patents have cited this patent, and that cited by, I think, is going to be forward citations, and all the patents that it is citing will be the backward citation. So just have a look at it, and if possible, answer some of these questions in the chat, and otherwise we will continue. Let me see, there is some chat, like a bibliography. Yes, there are 171 citations in tagging digital media. It could be, yes. 759. Yes, I think these are backward citations. Mohammed Roshan. These are backward citations. The forward citations are even more than 759, probably 1200 or 2000 even. So they have been extensively cited. Many technologies, many companies have built upon this patent. And if you see the text of the patents, the PDF file of the patent, it's quite an incredible patent to really see how high quality work that Apple has done. So, okay, I think given the time, we should move on slowly, because we also want to run some searches in like the next 30 minutes. Just for touch-sensitive input devices. That's the one. That's the one. Medicine or diagnosis? Well, the concept is the same for claims, for citations. So far, I'm just making the concepts. So Saksham, really, yes, 100 claims. It has 100 claims. You're right. So yes, let's move on and complete some other important concepts. Types of patent search. Okay, Okay, now that we are on to patent search, let me like tell you, like there are usually two kinds of patent search. You can actually call them by different names, but in eventually you will classify all patent searches that you do based on prior art search, which is basically novelty search. You are looking at everything out there in the public that can invalidate your patent. So here it mentions any piece of prior art, active or inactive, that affects the patentability of your invention. That is like the prior art search. And then there's a freedom to operate search, which is also called an FTO search, which actually looks at all the existing valid patents as in enforced active patents. So patents that your product might infringe. So when you're launching a product, like I said earlier, you want to see if there are any active patents in that jurisdiction where you intend to, for example, sell your products, to make sure that you don't inadvertently infringe. So this kind of a freedom to operate search. So there are two types of search. The way you approach it will be rather similar, except for the fact that you will search pretty much everything before the certain date for prior art, and for freedom to operate, you will only search for active patents. Some idea about patent data and its sources. So patent databases, there are a lot of free patent databases. Okay, and personally, I use eSpaceNet and Google Patents. PatentScope sometimes I have used because it has a good library of translated keywords. But as such, PatentScope, it's rather for technical people and not for the general public. But eSpaceNet and Google Patents, we will do a little bit of both today. And these databases are great. You can do text searches really well. It's not very good for analytics, not very good for making charts, figures. They don't have necessarily very clean data on patent applicants. So there are some drawbacks, but for inventors, because they are free, it is a brilliant source of data. It's comprehensive. They both have, I think, 100 million coverage. Actually, IPgram, our tool, is also having data from eSpaceNet. So we are buying data from eSpaceNet and we are building an analytics on top of it. So we know their coverage quite well. And then there are these commercial patent databases, which are giving a lot to you, in terms of translation of claims. Depending on, your use cases, there's a wide variety of databases out there. So, but again, pretty much all of them are rather expensive. But I'm sure that as an inventor, you can really, really deal with just Google Patents and eSpaceNet and possibly India Patent Search. I'll also show you the India Patent Search tool to give you an idea. Shall we move to eSpaceNet? I will skip this exercise. Let's go to this quick and dirty patent search. So let's move to eSpaceNet. I'd like you to open eSpaceNet from this website, espacenet.com. It's actually a patent database maintained by the European Patent Office, and they actually have agreements with all the patent offices across the world, where the individual patent offices report them the data, and they have I think around 110 million publications in their database in espacenet.com. So global publications. So it's very comprehensive. However, when I say very comprehensive, both Google Patents and eSpaceNet, they have very bad Indian data, that they don't have comprehensive in Indian data. So if you want to do a prior art search, probably you have to first search Google Patents. And for India specifically, you might have to search the Indian Patent Office website separately to be sure that you have checked everything. But yeah, some tools, commercial tools are out there which have good Indian data, but mostly they don't, because Indian Patent Office is not making available very good data. So we went to great lengths ourselves in IPgram to acquire Indian data. So is providing citation compulsory? Well, not in every patent office. It depends on the patent office. Why is Apple patent filed only in US, Canada? Is it so? I would imagine it would be filed in a broader jurisdiction, but yeah, I'm not the right person to answer why they did not go to worldwide. Okay, so let's do a quick and dirty search. I hope everyone has espacenet.com. So the first thing I want you to do is just search what you have in your mind, whatever your technology is. Just type it as a technology phrase. Don't think about operators. Don't think about anything. just type, say, wind turbine. I've given you some examples: electric solid state batteries, electric bicycle battery assembly, or anything that you are doing right now. Just type it as a technology phrase, and I will show you that why even this is a great way to validate an idea, because I'll show you also why you should do when you have to do very precise search, and when you can just do quick and dirty search to get by. So, and I'm sure when you do this kind of search already, you will get some surprises, some patents that are very relevant to your topic, your subject matter. Let me see one certain slide that I thought I will show you. Okay, no, that slide was basically, I cannot find it right now, but that slide was basically on, when you have to do, for example, if there's an infringement lawsuit, okay, then you have to hire very specialized patent searcher, because now, stakes are high, and you want to make sure you don't miss any prior art. You do a very comprehensive search, because that's a totally different ballgame. Okay, but if you are an early stage inventor, you have not even filed a patent, you're validating your idea, it is fine to not do a comprehensive professional patent search. You can still do a quick and dirty search. That is why I think this kind of search, all technology managers, all incubation managers, or uh, inventors themselves, they should know how to do it, because it is the first basic thing. You want to validate your idea, right? You want to validate and develop your idea. These are the two things. So because you are right now in a stage where you push your idea towards becoming an invention. So I'll just give you an example. How it works, this quick and dirty search. Actually, I'll have to change my sharing settings to desktop. So please bear with me until, yes, now I can share my entire screen. So I will do it with you. Just, watch me how, you can go very precise. So here it is. When you go to espacenet.com, there it is, open espacenet. They have also a classic. Some people still prefer the old espacenet, which I think was even, yes, in some ways better than this one. So yeah, I'm typing wind turbine here. Just one example. You can type anything you want, and I want you to take a look at the number of hits. So these are the number of hits. So when I type wind turbine, I got 200,000 plus patents. So that's like enormous, right? Nobody has the time to go through all these patents. But the thing is that they are sorted by relevance. If you see the most relevant patents with terms of the keyword, so they have their own scoring. So whenever these terms come together, or whether they come very many times in the patent document, they score the patents higher. So you can see, if you click on the top patents, you will see that they are more or less, they are going to be very relevant to the wind turbine field in general. Okay, and you can see a lot in eSpaceNet. You can see bibliographic data, descriptions, claims, citations, original document you can download as PDF, legal events, families, members, and everything. So all the things we talked about, you can have a look in here. But now here's where this quick and dirty search becomes very powerful. Suppose wind turbine is a very broad field. Okay, as an inventor, of course, you want to know more, right? You are probably doing something very specific, not something so broad. And so now you see 200,000 results. Now you are an inventor working with generators. So I just typed an extra keyword, generators, and watch how the search became more narrow. And this is because, again, this is sorted by relevance. Now it gives generator as a very important part of. So now you can see all the patents that you see on the top, they are related to wind turbine generators. Actually, even 46,000 is a lot, and even wind turbine generator is a very broad field. So, likely as an inventor, you're doing something very precise. Suppose you're solving a problem, because these generators produce a lot of heat when they are doing when they are operating, they produce a lot of heat. And suppose you want to solve the problem of overheating inside the generators, and you just type wind turbine generator cooling. So all the patents that are helping with the cooling of the wind turbine generators. So now you can see already you are getting much fewer results, right? 9,900 only. And again, you don't have to still see all these 9,900 results. You can just go by the by the relevance score, the ranking that they are having. So likely you have to see the top 20, 50 patents, and pretty much certain if you write the right keywords, you will find something relevant. So you can go even further. Suppose you want the cooling to be done by water, or can be done by some kind of an oil. You see, again, the results come down. So the more keywords you add to your query, the more precise the relevance score will become, and the more precise your more narrow the number of results will get. So this way, this is how you can progress. You can add features and specifications to your idea and keep adding them. So suppose there's a pump in the system. You are inventing a pump that properly circulates the water within the cooling jacket of the wind turbine generators. So you can see every time I add one feature or one object or one specification, things are getting more narrow. So this is the overall idea, right? You want to have a narrow search. You start broad because having a broad search also gives you an estimate of what's out there and how much activity is there in a field. But then you keep adding features, and actually this is a way also to mature your innovation, your idea to in inventions. If you want to get a patent for your idea that you have in your mind, you need to add features. You need to add a lot of specification to your ideas to really come up with this. Okay, I hope this was interesting for you. Just write in the chat if you found this interesting and relevant in your use cases. I'll be grateful if you can give some feedback. Great. This is again a quick and dirty search. I think everyone should know this search. Everyone should know this search. Let's move on to the slides. Okay, so a little bit more on text searching since now we are at the topic. So let me see. Okay, we are already past an hour. So yeah. I'll tell you some details about the advanced searching, and I'll give you probably some references. So I actually conducted a comprehensive webinar, 2-hour webinar on Google Patents. I'll probably share the link with you, so you can see some very detailed things in Google Patents. So, but yeah, so this is where advanced searching comes into the picture, and this is where the experience of the person who's searching comes into the picture. They know how to deal with patent jargon because patents are written in techno-legal text, right? We know that lawyers write patents, and a lot of times you will see a spring is sometimes called energy storage means. In fact, even a battery is written as energy storage means. So it might be confusing. You're looking for battery patents, you're writing battery, but you're not getting anything. So it could be that energy storing device. Sometimes they are referring to the battery as. So you need to make sure your bases are covered if you want to do a comprehensive search. Like ball bearings is usually going to be written as plurality of balls. Drone is written as unmanned aerial vehicle. UAV, sometimes the acronym. Remotely controlled aircraft, remotely piloted aircraft, whatnot. So drones are especially a bit tricky. And in fact, drone is also some pharmaceutical drone that it's used. So sometimes you can even get pharmaceutical patents if you search just drone with some wildcards. So again, cooling, we wrote cooling in our quick and dirty search, and guess what happened when we wrote cooling? So sometimes they are not writing cooling at all. They write the concept like the heat transfer or a heat sink or a heat exchanger. So we are losing out on many patents. If you saw, we had at the end around 4,000 something patents, but that patent search was not professional enough because it did not account for synonyms of cooling like heat transfer, heat sink. So if you can account for those, you can, you will probably enlarge the results. It will not be 4,000 anymore. Probably it will be 5,000, 6,000, but you would have had, retrieved some more relevant patents. Okay, moving on. So just another exercise quickly. I would like you to make these 3 searches on espacenet.com and just write on the chat how many number of hits you have got. Okay, that's the exercise. Just use espacenet.com, write the number of hits, and this will make you understand what these operators are. These are the three most basic operators, and with if you scale these operators, you can do very professional pattern searches, even like as a beginner. So really, there's nothing more to these operators than scaling them. So yeah, I will do it with you so that we don't waste any time. So eSpaceNet is already open. I'm gonna copy this. So that just write on the chat number of hits you get with these fuel or cell, fuel and fuel cell in quotation marks. Uh, Fuel or cell is 700,000. Yes, you're right. You can see or is basically you see fuel or cell. Either of these words can appear in the text. So this will be a really broad search. But as soon as you do it and, you become much more narrow, because now you are saying that you want to search fuel as well as the cell. Both of them have to be present. So from 7 million, it became 400,000. That's like, I think less than 10 times or something, 20 times even. So, and if you put in fuel cell, that means fuel and cell, the two words, they have to be together. Fuel and cell would mean fuel as well as cell can be anywhere in the document. But fuel cell is like both words have to be together. Fuel, so it cannot be fuel in one place and cell in another place. So again, you got the most narrow results when you did fuel cell, right? So folks, this is pretty much about the operators. Of course, you can have one more like fuel not cell. So this also works, but this will be the broadest. This will be like the word fuel has to be there, but the cell cannot be there. The word cell cannot be present in the. So these are like some like 2 or 3 operators which are like common in pretty much all the apps. Maybe some syntax changes are there, but all the apps will have these few operators which you can scale. After filing the application, Nikhil, I'll answer this a bit later. Please ask me the same question after the end of this session. So since we are on to this topic of searching right now. So fuel and fuel cell without quotes is the same. Just have a look, Aryan. I am not aware, but just have a look. So, but yeah, I think that this exercise gives you an idea how to scale these patent searches. And now we will run one final query and conclude patent search. Okay, Google patents I try not to cover today. But just one exercise. I'm going to leave you to do this exercise on your own. Just take a screenshot of this screen if you want. And I will just give you a hint before I leave you. So this is like all the things that we learned today. I have combined them. So this is our exercise. Creating high efficiency fuel cells requires proper cooling. Actually, it's very important. And for the fuel cell system to run well. So what you need to do, there are 3 concepts that I want you to search. One is fuel cells. Of course, you want to search about fuel cells. You have to search for fuel cells only in vehicles. So it has to do something with vehicles, cars, trucks, or whatever. And there has to be a cooling arrangement. So there are 3 concepts which you have to separate them all with an AND operator. So if you can see, the first exercise is very simple. So you use this kind of a notation. So I want, instead of keywords, I have put concepts. So fuel cell is one concept. Okay. And it has to be something with vehicles, and it has to be something with cooling. So now you can see already, you can be sure this is going to be a rather narrow result set. So 34,000, and plus it will have the high relevance score on the top. So already you can see a lot of interesting results for fuel cell vehicle cooling, circulation, and so on. You can add more keywords if you have more specificities in your invention. You can feel free to add more. But what I want to show you is one more thing, how you can broaden this. So just I was saying you about cooling, heat transfer, and so on. You can see, or you can see vehicle can also be a car, right? Or it can be a truck, or it can be an automobile, and so on. So here I made a group with a concept. So this between the and, it's a group separated by or operator. So this is going to broaden the search a bit. if you saw maybe 34,000, I think, yeah, it's now 40,000. So just because I captured like 6,000 more patents because I did not miss out a synonym. Similarly here, you can have one more thing. You can have a wildcard. Wildcard is also a very important concept. So I'll just zoom in a bit so you can see. Here it takes into account cooling, coolant, cooled with an ed. So all these synonyms are taken care of if you use a simple wildcard. And again, you will see how many patents we missed because so even up to 7,000 patents we missed because we did not use a wildcard. So yeah, I mean, depending on your situation, you want to go broad. Depending on your situation, you want to go narrow. Probably if you are a very technical person, you want to do narrow search. If you are doing, for example, I was making a regional innovation report on nanocellulose. So it was not specific. It was just nanocellulose, and that's it. So it was a rather broad subject. We are not saying nanocellulose for this, for say healthcare applications, or nanocellulose for some other applications, and so on. But only nanocellulose. So again, you can just type nanocellulose, and it gives you a broad set and go on. So depending on the goal you want to achieve with your patent search, you want to decide whether you want to go broad, whether you want to go narrow. So yes, you can probably add some keywords like heat transfer. Maybe this works. And yeah, you can see a little bit more, it increased by 1,000 more. And that's about the concept that I'm trying to explain here. So folks, I would like you to take a screenshot of this and help yourselves work it out. And yeah, so this pretty much, I think I will conclude the search part with this session because there's really, we can talk more, but it will probably not serve the purpose. So let's go a bit into the India patent filing part. So a little bit on notes on India patent filing and notes on basically inventions, basically being more innovative, how to mature your innovation. So let's see the chat. Synonyms to make the search difficult. It could be true. So it could be true that some things are done deliberately, but some things can also be like the industry standard. Like something can be just, if you are an experienced searcher or a patent attorney, you will know usually what are the tricks of the trade. And also if you do a broad search, you can look at few patents and then see what synonyms are coming. Okay, so this way you can write in an Excel sheet, you first write all the synonyms that are possible and then build your query after that. That's how a professional search would go on. Doesn't contain, yes, not means doesn't contain. So if you want to exclude certain keywords, yeah. Process of filing patent, yes. So actually we are having even on our platform Turnip, if you go to our website, you can sign up for the newsletter because we are having a lot of events. We recently had a Q&A on Indian patent filing with a very experienced patent attorney. So personally, I am not a patent agent. I don't file patents, but we are doing about 1-2 filings every month nowadays with associates. So I have got a good idea about the patent filing process. So first, I want you to understand the difference between an idea and an invention. So if you want, can you write on the chat what you think is the difference between an idea and an invention? If you can write it on the chat, it'll be great. It'll be a great starting point, to really understand, what your filing is going to be useful, will have a chance in the future or not. Let's see if we have any comments. Invention is a reality. Yes, you're right. Idea may be practical or not. Yes. Supported by data. If we have a prototype. Yes, yes, pretty much everyone is correct. Okay. whereas idea is just in the mind. Yes, you're right. So yeah, let me also tell you my own definition. So an idea becomes an invention when you can describe it in sufficient detail. So here, sufficient, the word sufficient can be really quite extensive. So it's a way of saying that if you, idea is like, a stone. If you start carving it, you extract features out of it. Like there's a, stone artist. They start with a stone, and they chisel it, they extract features out of it, and then the final product is a very beautiful statue or something, right? So that's the overall idea. That idea is really in your mind, but when you start describing it, when you add really, really precise details to it, that's when it becomes an invention. So can an idea be patented? No. Can an idea be copyrighted? No. So there is really no protection out there for ideas. So it's in your mind, and usually it's not very valuable. Uh, so this is where writing can help you. So like I think Amjad sir, he was telling that you have an invention disclosure form. So I added one slide on invention disclosure form on my own experience, and as well as what I think about invention disclosure forms. So writing is a very important factor. Only when you write, you will be able to extract ideas. Okay, this is how the invention works. This is what the external environment looks like. This is what, uh, all the different parts of the invention. This is how they interact with each other. All these things, when you start writing, you are becoming more of an invention. And use an invention disclosure form for guidelines. And I will tell you a little bit that invention disclosure form is actually where innovation is happening. Okay, so if you think that it is just a formality, then it's a problem. You will see that why, when you are filling the invention disclosure form, it asks you some questions, right? So this helps you to think about your invention, and add features to it. So it can even take you 1 month to fill an invention disclosure form. So by all means, take 1 month to fill it. But the thing is, while you are writing, innovation is happening. Innovation is progressing. So you have to take the invention disclosure form very, very seriously, and write all aspects in a as precise way as possible. So what problem does this invention solve? Of course, you have to write that. What commercial applications are there for your technology, because that's, and you have to write that. Otherwise your patent might not be granted if there is no commercial application. Of course, you have to describe the invention in detail. How does it work? What are the components within it? How they interact with each other, and so on. And how are you different from existing solutions that solve the same problem? So this is also helps you to identify the novelty of your invention, or the inventive step of your invention, and so on. And a brief prior art search is needed even at the time you are filling the invention disclosure form, because just like I taught you, the quick and dirty method, at least that is needed, because your invention disclosure form should ideally have a bunch of prior art search also, where you can say that, okay, these people have done it this way, and you can highlight your part where you are innovative. You can highlight the part for which you can get the patent. And finally, as a summary of what I was trying to tell, invention disclosure form is not a formality. This is where actual invention happens. This is where actual innovation moves forward. It's a way to push your innovation into something that can in the future be qualified as a patent. So yeah, these are like my 2 cents on invention disclosure. So quickly, I'm going to look at the chat. Commercial application means basically industrial applicabilities in real life. You have to say that, okay, what problem your invention solves, and how it helps. Can idea be patented in India? No, it cannot be patented anywhere. So okay, good. I think I'm glad that so many of you are writing, and you are involved in this process. So yeah, to write some guidelines I have mentioning here. So when you're writing, you can broadly define, first of all, what the problem is. You can say how are the various components structured, and you need drawings, of course. So the first drawings are usually drawn by the inventor themselves. And drawings are going to be very important. It can differentiate between a good patent and a bad patent, or whether even your chances of success can depend on how good drawings you make, or flow charts of different components, and so on. Describe each element and how do they interact with each other. And if needed, you can also describe the external environment. You should describe the external environment. Like, for example, does your invention need a external battery supply. What is the voltage of that battery supply? Can it be operated indoors? Will you need to heat up your solution to a certain temperature before you can proceed? So these are some of the external environment in which your invention operates. Describe the overall function. Write the differentiating points with prior art. This is where your invention is happening. This is where you are saying that we have added this new things to the prior art. And always remember that no one knows more about the invention than the inventor themselves. So inventor is the one who will have to do the bulk of the writing. So even if you take services from patent agents and patent attorneys, you are the one, because they might be involved in 2 or 3 projects at the same time. So they don't know so many nuances. They can guide you and they can help structure your text and write the claims. But pretty much all the writing or the drafting part or the description part of the patent has to be done by an inventor. Okay, patentability criteria, again, I think I don't emphasize it because we are running out of time, and also this is more about basics of IPR. So patents have, at least there are these 3 patentability criteria where it should be new. That means it should not be known to the public by any means. And this is where prior art search comes into the play, where you want to identify the novelty. And then it should be sufficiently inventive. That means that a person who's skilled person in your field should not think of it as an obvious, addition. So if you make a chair which has like 6 legs instead of 4, it might have an inventiveness problem. That okay, if someone skilled in that field could easily have thought, that thing. And the industrial applicability part, which I said about the commercial applications, that it should be useful in the broader sense, because if it's frivolous, it will not be granted. It can be grounds of refusal at the patent office. How to make sure whether your invention is patentable. I have mentioned some of the things, but if you want, you can click on this India Patent Act of 1970, Section 3. I will write it in the chat. So this is like Section 3 of the India Patent Act. So if you give a patent agent exam, you'll have to, read all this India Patent Act 1970, which completely defines in very much detail what are the laws related to patents. So I will just write to everyone. Okay, I'll answer some questions later. I'm trying to finish the stuff before. So these are the things which are not inventions, which are not classified as inventions. So actually you can read it, just it's not that much context, you can read it, but I have actually summarized a little bit over here. So you can see anything that is frivolous or contrary to well-established laws, contrary to public order or morality. Any method of agriculture or horticulture in India, it's not allowed. Any literary dramatic stuff, it's copyrightable, it's not patent. Any full plants or animals in whole, it's like not allowed. Any mathematical or business method or computer program per se or algorithms, they are not patentable. So because anything, for example, a mathematical equation, it's considered to be a natural law, and you cannot get a patent on a mathematical equation, even if it's new, because it's not going to be. And even a computer program per se, only the computer program itself, it's not patentable. The technical problem that it might solve might be patentable, so we can have a look into it, and so on. So yeah, for different industries, there are different professionals who can guide you better. But yeah, these are the overall idea about the. So contents, you will probably have to write these contents. So title of the invention, normally within 15 words, short, precise, relevant. Field of invention, a short paragraph describing what field of research you are in. Background of the invention, describe the state of the art, what problems are there in the current solutions, and mention the closest pieces of literature from your patent searches. Object of the invention, statement of invention, showcasing that, okay, this is what it's novel. Summary of invention, a description of all the drawings one by one. Suppose you have 5 drawings, each drawing one by one has to be described with a certain number, and a detailed description. So a complete picture of your inventions with details, methodology, flows, flow of events, and so on. And of course, claims, which is usually you will take help of a patent agent or a patent attorney to write the techno-legal text that define the scope of the protection, which is, like we mentioned earlier, one of the most important parts of the invention. So I'll show you a bit of timeline and some forms and procedure. But plants of breeds, again, Mohammed, I cannot comment on this precise nature of the things. But in the Turnip Innovation Festival, we are having a Q&A with Dr. Prachi Pandey. She's a patent agent with 15 years experience, and for biopharma, biotech, chemistry related inventions, she has incredibly precise knowledge. So she can really help, and she'll do a live Q&A over there. So, okay, just to also make you understand that innovation is a process and it takes many, many years. It's not a one-shot action. You cannot do it in 1 or 2 years. Even a patent grant can approximately, like on an average, takes up to 5 years after filing. And it can be a refusal also. So the thing is, people who have accumulated, tens or hundreds of patents to their names, they are inventors for life. Okay, so with experience, they become good at it. They know how the game is played of patents. And if you have a 10-year career as an inventor, you are likely to be churning out 2 or 3 patents every year. If you make up, if you can file that many patents. So, but usually as a young researcher, you might say at first you need experience to get the first patent granted, and then learn from the mistakes and so on. So patent filing, once you do the filing, which is the first filing is called the priority filing, which is the closest to the invention. That date is the closest to the time when the invention actually happened. And then you have 12 months, according to certain international treaties like the Paris Convention. You have 12 months to file the same patent in different countries, like to expand your patent family. But if you miss that window of 12 months, you will probably not be able to. You will not be able to do it. Your own patent will act as prior art if you make a filing abroad. And then usually 18 months after filing, your inventions are published by the patent office. That means it becomes public. So that's when it comes in the database. And after publication, there's an examination process where the skilled examiners are, conducting prior art search and everything to establish the patentability criteria. That, okay, your patent satisfies all the criteria. And if not, they might give you an FER in India. So I'll show you a little bit about FER also. And then there'll be a decision. Once you solve all the problems, all the objections that the examiner has raised in the FER, which is the first examination report, you will get a grant or a refusal. And the grant can also be challenged by third parties in various opposition measures. And your refusal can also be challenged by you in the form of appeals. But for Indian Patent Office, I made a specific one, this timeline. So this timeline, I said, it's like pretty much for every patent office out there. This is like very approximate and on an average. But this one is more for an Indian perspective. So you do a patent filing and you can do a request for early publication. There's a form for that. And you can just request publication. It's published in 1 month, or less than 1 month, even sometimes 1 or 2 weeks, it will get published after filing. So request for publication costs you a little bit money, and then it will get published. And if you don't submit request for publication, it will automatically be published 18 months after filing. And then there's also this thing that in Indian Patent Office, automatically patent is not going to be examined. You have to file a request for examination. That means there's a form where you say, so in that form, you have to file within 48 months of your patent filing. So 4 years after filing, you have the time to submit a request for examination. But we usually do it, most of our clients, they do it at the same time as filing. They just file a submit request for examination. Basically means that examine it as early as possible. So only when they get a request for examination, they will start to examine your patent. And also it costs money. It's 4,000 rupees for individuals. So I'll tell you a little bit about the pricing. And as soon as your patent is published, anyone can submit a pre-grant opposition. Maybe your competitor or someone, just who has stakes in that field, they can file in the patent office a pre-grant opposition. That means that they will challenge your patent that, okay, it's not novel and it should be rejected, ASAP, and so on. And after the examination is done, your examiner is going to give you a first examination report, FER. And if you, so it's very usual you will get an FER. There's pretty much no invention that will just straight away be granted. So if you properly address all the objections of your FER to the examiner, you will get a grant eventually. And then the grant will be published. And even after publication of grant, there can be a post-grant opposition. That means any third party can still oppose your patent. They can still say that, okay, look, we have found certain prior art where your patent should not have been granted. They can advise the examiners to review the patent application and so on. And then every time a grant or a pre-grant opposition or a grant post-grant opposition is made, you will be informed by the patent office that somebody has submitted these observations. So you might have to respond to those observations. Okay, let's look at a bit of files and fees about the patenting. If two people claim a patent in two different countries, but one of them gets filed before. Look, Shashank Singh, there are laws for this. Each country has its own law. But you see, I want to keep this session very practical. If this is something that is happening in a very practical situation, that you are likely to be in such a situation, then, we will get into details. Each country has its laws. Like US has the first inventor to file. India has the first person to file. So even if someone else invented it, but the first person who filed gets it. And then there are these dates between priority dates. So a lot of things can be assessed. In case when or appropriate time to publish your, okay, Nikhil, again, I will have to answer this to you a bit later. Okay. So let me show you the forms and fees, actually, just so you get an idea. So this is the Patent Office forms and fees page. I'll put it on the chat to everyone. And I will give you some idea about it. So let me open this fees. So you can see, I will just show you some fees. It's very complicated. Actually, there's a fees everywhere. You can see 8 pages and it's very, not very. So you can see for a small person, like individual person or a startup, the filing fee is 1,600 rupees. So it's for both e-filing. So I think for physical filing, it's at 1,750 rupees. Yeah. So we are interested only in e-filing. And actually they have removed this 4,000. Just last month, a circular came. They have removed this 4,000. So even small companies and startups, they are coming in this 1,600 rupees range. Big companies and organizations, like even institutes, universities, they come in this bracket. So for institutes, it's 8,000. Actually, for every, it's 5 times more. So for all the fees. So basically, government is giving 80% discount. So 80%, 20% of 8,000 is 1,600 rupees. So they are giving 80% discount to all small entities, startups, and everyone. And this application, you have 30 pages. If you exceed 30 pages, you pay per page. And you have 10 claims, you can write 10 claims. If you exceed 10 claims, you have to pay per claim 320 rupees, and so on. And then there's renewal fees. You can see the first year renewal fee is less, 800 rupees. Then, after that, by the 18th year, you have to pay even up to 8,000 rupees as renewal fees. So renewal fees keep increasing. There's a lot, but you know what? I'll just summarize it in a slide and you can look at it later. Okay. So there's this thing like Form 2. You can file 2 kinds of patents. One is provisional patent and one is full specification, complete specification. Actually, you can file many kinds of patents, but that is a discussion for another time. So provisional patent, what is it? It's also a very interesting concept that provisional patent basically is a petty patent. It is not published. You don't need your invention to be completely ready when you are having a provisional patent. It gives you a priority date that once you file a provisional patent. So in the Form 2, you have to mention whether your patent is a provisional patent or whether it's a complete specification. Complete specification means it's a full patent, like how we know about patents. It's a complete patent. Provisional patent is like, you can just describe the invention roughly. You can just write one claim broadly and you can submit it. Theoretically, you can even do it as an individual. So it helps you to secure priority. And after the filing of provisional patent, you have 12 months to file the complete patent, complete specification. So this 12 months, gives you time to assess how, what are the potential of your ideas, what are the commercial applications and so on. And it gives you can study the commercial viability, do marketing of your invention, see if somebody can fund you, and many things. And all this while it's not published, so your secrecy is maintained. You're not, losing. Somebody cannot just copy your idea. And if you think after 12 months that you have potential in your innovation and you can do real business with it later, or sell your invention or whatever, you go ahead and file a complete specification where the charges are usually higher. So yeah, this is about form 2. I'll explain to you about forms also. So what forms you will, in the beginning at least, need to fill. So yeah, you will of course have to put this, that your applicant 1, 2, 3 statement of undertaking. These are the 3 forms you have to put, definitely. Form 5 you have to put, so the declaration of inventorship. Then there is, I think, 9, which is request for publication. This is optional, 2,500 rupees for individuals and 5 times more for universities. So it will be early publication, basically, form number 9. And then there's a request for examination, which is, yes, form 18 and form 18A. There are 2 forms here. And if you are using services of a patent attorney, which likely you should and likely you will, then you have to fill also form 26, which is power of attorney, that another patent agent is going to do it for you, form 26. So yeah, these are, I think, 5, 6 forms that you need in the beginning only. And then the rest are depending on opposition. There are for all different things, there are different forms. And with the fees form, you have to pay the fees, like 1,600 for the filing, form 2, 2,500 rupees for form 9, if you want early publication. And form 18, it will be 4,000 rupees, like request for examination for individuals. So that means 5 times more, 20,000 for the universities. So folks, this is it. Basically, this is all you really need to know to file Indian patents. I mean, I suggest, I have compiled this sheet, the general info and tips and tricks, to basically summarize all the things I have mentioned. And yeah, so filing fee for individuals is low, 1,600 rupees, and 8,000 rupees for universities. I already told you, you can file a early publication, 2,500 rupees. Your patent is not automatically examined, so you need to file examination request, which is form 18, 18A, and that is 4,000 rupees. And yes, you will need to answer the FER. So once you receive FER, first examination report with objections from examiners, you will have 12 months to file the answers. So general tips: adopt and implement a comprehensive invention disclosure procedures, both from the institute as well as from the inventor part. It has to be 2 ways. Involve a patent attorney as soon as possible, because they will not only help you file your patent, they will guide you. They'll know the clever tips and tricks to go around prior art. If an prior art is particularly problematic for you, they will tell you how you can, navigate it. So in more ways that they will help you to mature your invention. So it's just invaluable to have someone experienced have with you in your journey. Yeah, so whatever I said, basically, I've summarized it. They will help you extract the invention from your idea, simply what can be patented, what you should focus on, and so on. They can also help you do professional prior art search to basically enrich your invention, identify novelty, and so on. And of course, they will help you to write claims, which should be entirely left among experts, in my opinion. Do not delay filing a patent, and if you're unsure, file a provisional patent. Consider filing a provisional patent. And overall summary is, hard work is needed at all steps. So right from invention disclosure, actual invention part, documentation, the whole procedure, it takes hard work, ingenuity, creative will, collaboration, and all these things for you to become successful. So folks, this is all. Please feel free to contact me. Feel free to get in touch via these email, LinkedIn, and WhatsApp on this phone number. And now I think is a good time. I'll take some questions and probably conclude after I've answered some questions. So And yes, I will also tell you a little bit about our Turnip Innovation Festival. So basically, the keynote talks in Turnip Innovation Festival, they are free of charge. Anyone can access it. I will mention the link where you can register for the keynote talks. Actually, you can see here, if you see my screen, there are 4 keynote talks. Munish Sudan, who is a head of IP, intellectual property from Tata Steel, he is going to be the keynote speaker. We have a head of Qualcomm IP, Dr. Hemang Shah, who's speaking on design thinking. We have Dr. Purushottam sir, who is chairman and managing director of NRDC, and his speech, he has already been on our platform, so his speech will be invaluable for technology commercialization, funding startups, and so on. And Dr. Chandan Bhar, he's a 24-year in R&D, pharma R&D, so he's a strategist, patent strategist, and he will speak on healthcare innovation in post-COVID times. So there's no registration fee for this 4 talks. And if you want to completely absorb the event, like all the keynote talks, all the knowledge talks, entire thing, there's copyrights, there's trademarks, there's Q&A with Dr. Prachi Pandey, secrets of writing claims, and also expo from our sponsors. You can also register for it. So yeah, it's like cheap, 249 rupees for till 31st December. And what else? Actually, with your certificate, if we are issuing it, I can also give you my patent information course if you want. I have covered very broad topics on patent information. So patent course basically on global filing systems, how you file PCT, how you go to different countries, what are the different strategies people are having, and searching, landscaping, analytics, so much, like all of this in like 14-day simple email course. This is a simple email course. So can you explain the difference between a copyright and a patent? Yes, okay. So yes, I can start to answer some of your questions. Well, Soham,
Rahul,
yes.
So I think we can also allow the participants to unmute and ask the questions now, because I think it's done from your side, right?
If they prefer, yeah, I'm fine. I'm really fine.
Okay.
So,
Yeah,
so
please
let me ask this. Yeah, this patent and copyright, I actually always get this question. The thing is, they are completely different. Okay, copyright and patent are completely different. Copyright is for creative aspects, like literary things, like if you wrote a book, like a song, lyrics, software code itself can be copyrighted. And all the things that are creative and new, of course, it has to be new. You cannot write, say, your thesis. It's assumed that you have done a new work, and that can be copyrighted. But patent is for technical inventions. They are for technologies, products that solve a technical problem out there. Like a machine, you've built a machine, that is patentable. That is not copyrightable. The design of the machine could be copyrighted in principle, but the thing is, then you have to explain that your design is so new that this kind of design nobody has ever seen before. So also that is an aspect where, so yeah, there's really, it's totally different, copyright and patents. We shared between two if they invent it at the same time. Well, they cannot be 2 patents. They can be 1 patent and it can be shared by different inventors. But if there are 2 different patents in 2 different names, I am afraid not. So yeah, please feel free to ask questions by unmuting yourself while I scroll through the chat. What is the scope of using automation AI? It is being done. But I think that the techno-legal people who draft the patents, they are more clever right now than the AI. So AI, I think brute force is still used. So, but there are tools. I know some tools which are saying AI, but I am a bit skeptical about how well they work. Okay, so Nikhil, in case of Indian patent application, when or what is appropriate time to publish your work in international journal after filing the application? It should be no problem. It's if you have filed a patent, it's the date on which it will be evaluated as that. So a prior art has been created on the day of filing of your patent. Okay, so I don't think it's a problem to file a journal paper after that, immediately after that. So yeah, I'm not an expert in this, so I wouldn't say for like legally sure way. But then maybe the journal has some guidelines that if it's exactly same, then your journal should not be published, right? It should not be accepted because someone can say that it already exists. But I think that immediately after that is my guess that you can make a journal article. Will be cross novelty criteria. Notes created by inventor while discussing with mentors will cross novelty criteria. I mean, it's good to have your notes because they might be important at some stage to define that, okay, your invention was created by you and at a certain time. But as such, it should not have anything to do with the novelty criteria, because novelty is like this. There's a piece of prior art, and the date of your notes might be might be a thing which works in your favor, maybe if there's a dispute. So these are all unlikely scenarios. So Akshay Joshi, is it a scenario that you are facing now, or are you going to face it anytime soon? So this, just think about it, and so I'm sure some expert would be able to tell you the exact law behind it, but my job really, I don't think, is to say about exact law. Plants and animals, no patent, like the full or part of plants. Say you say, even if a new plant is out there, you cannot patent it. So part of the plant or part of the animal or whole plant or animal, this cannot be patented. Okay. Akshay Joshi, please get in touch with me. Okay, I gave you my contact. I will try to help you out, either myself or with somebody's help. Indian rice have been unauthorizedly patented by companies in US. Okay, interesting. By companies in US. In India, you can see, you can see what they have claimed in the invention, what exact thing they have claimed in the invention. I'm sure they have not claimed the part or whole of the plant itself, but there's something to it, or there's some plant breeders variety that they have done, because otherwise it will be grounds for refusal or invalidation. Yeah, plant variety are protected under separate act. So someone, yeah, you have answered. So yeah, I mean, I'm not a chemistry or a bio person, but we have multiple sessions. Actually, we have one specific session by Miss Mansi Chaudhary in the conference, innovation conference, on biotech patenting in India. I think that would be a great place to absorb all the knowledge that Mansi Chaudhary has. Great. I really appreciate that the audience has been so interactive. They have pretty much done all the exercises.
Rahul,
And yes.
So let me ask a question.
Mm-hmm.
Yeah. So thank you very much for this very nice interaction session. So towards the beginning of the session, you were mentioning that when a person is going through the through the literature, whether it can be patents prior, I mean, which were patents which were filed earlier, or publications, then he might come across multiple ideas which were already published in some form. Mm-hmm. And then when the person realizes that, if he combines all these ideas which were already published somewhere, and then realizes that a combination of all these ideas or a
mm-hmm.
can solve can develop into a product which can solve the existing problems in the market, or
mm-hmm.
or if it also has commercial application, mm-hmm. then can it also, so does this, is it sufficient enough to call it as, so is this condition sufficient to like file a patent, or because ideas
yes.
are I mean,
Yes, it is.
because
It
the
is
ideas they are
sufficient.
already.
Yes, it is sufficient. So I'll tell you, I know from like European patent officers, they are very, very sophisticated in their approach. So they have this concept of categories of citations. That means if you have combined some knowledge from two different documents, they will categorize it in a specific way in prior art. And if you have combined from three people, and if you combine from two places, they will mention it in the prior art, and they might say that this might cause you to fail the inventiveness test. Okay, but not necessarily, but it might cause you to fail the test where it's not sufficient enough progress over prior art. But they are saying that if you combine from three places, then they're already considering it as ingenuity. They're already considering it as some person who has added some value to the. So yes, I truly believe, and actually, if you really think about it, pretty much all patents out there, you can find places where they have, they have not copied anything, but they have, used ingenuity to combine ideas that together is sum of the whole, right? It's greater than the sum of the whole. So that's the overall idea. So I believe you can get a patent by combining ideas.
Okay,
And
so let me share my experience here. So I think it was almost 3 years ago. I had applied for a patent application in Germany, and so I wrote a application, and like along with my supervisor, who's a professor there, and then our application was sent for review to a, I mean, so the university has sent our application for a review by some independent authority, and then the review was negative. Like what they said was like whatever ideas which I mentioned in the patent, they were already, I mean, so I cannot really claim them as my new ones, and so
yeah,
so it's not defendable. Yeah, I mean that's the.
Yes, so this is a case specific thing. I'll have to know more details, but in principle, I'll tell you what is the criteria. That this is of course subjective. This is subjective. That means, so the guideline is that a person who's skilled in your field, do they think that this is sufficiently inventive? This combination that you have done, do a person who's skilled in your field, not an average person on the street, but a person who knows your technology field, do they believe that you have done something sufficiently inventive? This is the criteria on which examiner will judge. If they feel that a technical person thinks it's obvious, they will have grounds of rejection. This is how I think it will go.
Okay, so yeah, I mean, and also I think I have heard things like so your idea can always be patented provided that you write the text in a proper way. I mean, like, so there is a certain way to express your ideas or make your claims. So is that also playing some part, or?
Sorry, please, can you repeat it? Like just the last part.
Yeah. Okay. So I have also heard things like when we want to patent our idea, so there should be a specific way in which you need to express your claims and write the text. So provided that you write the text in a proper way, like in principle, many of the ideas can be patented, and
idea cannot be patented. So we just talked about it. Idea has no value. But yes, you have to write your patent text, and I gave some guidelines on writing if you followed. So like, yeah, this kind of, so these are some guidelines. You define your problem, you tell all the various components how they are structured, you define how your components interact with each other, you describe the internal environment, the overall function, the points which differentiate you from the prior art. And then I also had this slide where these are actually, in an Indian patent, these will go, all these parts it should be there. So title, field of invention, background of invention, object of invention, statement. So I have basically just summarized it in one slide, how it should be there. So this is not an idea anymore. If you write all these things, it's not an idea anymore. Definitely, it's more towards an invention.
Okay, so thank you very much.
Great, thank you. So Soham, you are asking me something you can easily search on Google. So it's PCT. I think it's 153 countries. what are the countries, this PCT. So by all means, or feel free to do this course, patent information course. It has all the, it will make you read all the important things. So yeah, if there's no other questions, then happy to stay in touch.
Thank you.
See you later.
Okay, thanks, Rahul. So, dear all, on behalf of IISER Bhopal and CS2, let me take this opportunity to thank Dr. Rahul Kapoor for his valuable time and for conducting such an informative workshop. Especially, it's very rare that the resource person takes each and every question and concern raised by the participants. So, special thanks to you, Rahul, for addressing all the queries. I would also like to thank all the participants of today's workshop for their time and especially for such an active participation throughout the workshop. So right from the minute we started webinar till the last point, the participants were active and interactive. So thanks to all the participants. This workshop is just a start. So what we are going to do is we are going to follow the different aspects of IPR and we'll be organizing the events on the similar line in future. So all participants, please do feel free to let us know the aspect of the topic that you want to know better so that we can organize the event accordingly with the help of CS2. So my special thanks to Mr. Arun Thapar from ICE office for all technical support in organizing today's event. And please stay tuned with the ICE social media pages for the upcoming event. Till then, thank you and stay safe. Thank you.
Thank you, everyone. Goodbye. See you later. Bye-bye.